Michael Dorf. He's coming on this week to talk about what he actually does, teach constitutional law. He has been teaching his students some constitutional law, specifically as it relates to animals, which I bet you're thinking it doesn't relate to animals whatsoever, but of course it does, because everything does. Welcome, Michael. I'm excited to talk about this. I am really curious how this course was planned and how it played out. So what were the main challenges in formulating a course that did approach animal law from specifically a constitutional perspective?
Yeah, so, most animal law issues or animal rights issues arise in their own contexts. And, one of the things that's hard about teaching law students is they take classes in particular subjects, right? So they begin with contracts, tort, civil procedure, et cetera. But of course, the world doesn't carve itself up that way. So someone doesn't, if you're a lawyer, you hang out a shingle, a prospective client doesn't walk into your office and say, I've got a contracts problem. They say, I've got a problem. And so that's true of animal rights issues as well. So, if somebody wants to do a protest, say, and there are limits or there's an ag-gag law, right? They're going to be constitutional issues, but they're going to be other issues. So in some ways, carving up animal rights, animal law issues into constitutional law pieces is a little artificial. But, I took that as it is, and I thought about like what are the main ways in which animal rights, animal law intersects with constitutional law. And then I just tried to, do a different one each week. So the first week we talked about standing, which arises in lots of cases in which plaintiffs are bringing suit on behalf of animals, and there's a question whether the humans, some organization, or the animals themselves are legally entitled to show up in court. So those are standing questions. We can come back to that. The second meeting, I had John Denatire and Raphael Fassel as guests. I know you've had them on
Right,
this
they were
show.
on
Yeah,
talking about their new book
right.
about
And
animals
and
in
it
the
was it
Constitution.
was that my session was pretty shortly after you had them on the Animal Law podcast. John I had in person because he was in New York City, and so it was relatively easy to get him up here. Raphael, we zoomed in from the UK, and that was great. We can talk more about that. Next session, we talked about the New York Court of Appeals Happy the Elephant case. Uh, Technically not a U.S. constitutional law question, but the course was titled Animals and the Constitution. I didn't say which Constitution. Um, so I think that's actually, that played out because, in a lot of,
Totally,
yeah,
totally. You have to be
yeah.
flexible here.
Well, and in a lot of the sessions, and I do this in my basic constitutional law class also, we bring in comparative constitutional law. So, this is how we do
Wait a
things here.
second. I mean, not to get into the details, but I mean, that's a common law case. Like, how is it constitutional
Well,
in any country?
well, I'm glad you asked that question, Marianne. So, in New York State, there is a statute that codifies the common law right to habeas corpus. But in addition, the New York Court of Appeals has clearly said that the New York State Constitution preserves the common law right to habeas. And
It's kind of a reach, Michael, to be
no,
honest.
no, no. And insofar as the statute might not cover a particular opportunity, it's covered by the New York Constitution. And I actually had a case about 10 years ago in which I had occasion to invoke that principle. I was representing a peace activist who was trying to challenge an order that prevented him from engaging in a protest at a military base. And we were able to argue successfully that although he didn't fit within the statute, he did fit within the constitutionally preserved common law right of habeas corpus.
Okay.
All right.
I'm in. I'm
Okay.
buying it.
All right.
Totally constitutional.
Yeah. Okay. So then the following session was on constitutional rights of nature and animals. And this was mostly comparative, right? So we talked about decisions by the Supreme Court of Colombia. Some of the other cases, Latin America has surprisingly been a source for these. There's,
Totally in the forefront. Latin
Right,
America.
right. There's, some law from New Zealand about rights of nature. So that was really interesting, and it also opened a window into discussing sort of the differences between valuing nature qua nature, on the one hand, valuing species qua species on the other, and then on the third hand, valuing each individual animal
Yeah.
for their own sake. So that was a really great session.
Yeah, that is so important because just as environmental law always has uh, been formulated, rights of nature law tends to be very abstract, in its concepts. Not quite as much because it does like look at very specific natural entities, but not really focused on the same fundamental principle of looking at sentience that animal law is really focused on.
Yeah, yeah. And so of course part of what we talked about was where are there overlaps and where are there conflicts between these different ways
Yeah,
of
that's a
thinking about
great
this issue.
conversation.
Yeah, and it was. And then the next session we had was actually sort of core U.S. constitutional law. So, as most listeners are probably aware, under U.S. constitutional law, if the government wants to infringe a constitutional right, like the right to freedom of speech or free exercise of religion, it can do so if the law is narrowly tailored to a compelling state interest. And so we looked at two cases in which there was a question of whether animal protection might be a compelling state interest sufficient to override asserted constitutional rights on the other side. So then two more sessions. One was what I called free speech for animals, by which I meant on behalf of animals. And there, we just talked about ag-gag because there's so much
Great.
to talk about there.
Yeah.
And then the final session was on what I called animals and federalism. So we talked a little bit about National Pork Producers Council versus Ross, right? That's the case involving California's Prop 12, where the Supreme Court upheld Prop 12 against a Dormant Commerce Clause challenge. And I also distributed an article to them, written a number of years ago by a law professor, discussing whether the Endangered Species Act is a constitutional exercise of Congress's power to regulate interstate or foreign commerce, even as applied to intrastate species, which is important for environmental considerations and to the extent that those are useful in protecting animals and habitat.